This is because Mary Lee Edgar went on vacation. We've never done one of these without her.
Okay.
Oh, there he is.
There he is. Okay. All right, I'm gonna leave you guys then.
Right. Thanks.
What?
Hi. Jeff, how you doing?
Good, good. Hey, Michelle.
Hi, Jeff. How are you?
Just fine. Let's see. How many do we have? 21. So we still have a few more to climb. I'll continue to go ahead. I mean, I'll wait here until it's work.
Okay.
Well, it's 4 o'clock. Thank you, everyone, for attending today's program, Getting Paid. I think that's everything or something that all of us would like to learn. So, and thank you, Michelle and Mike, for presenting today. I'm Jeff Gill, Executive Director for AIAOC County, and you can see that we are today's course provider. And then there is our course number, and for attending today, you will receive 1.5 AIA learning units, and there's today's date. Why am I saying this stuff? It's required by national AIA. So if you could move to the next slide, please. So the course description, this course will cover the art of causing a client to want to pay and the legal processes available if they don't. I'll let you read the learning objectives. And one thing, if you could please, while you're reading those, make sure that you have your first and last name, because that's the only way we can record it. I don't have a way of doing so. Otherwise, I see a couple names in there. I've sent some private chats to you. If you are unclear as to how to change it, you can just send it back to me with your name, and that'll work as well. Next slide, please. So we have 10 days to record your learning units. I plan on doing that tomorrow morning, so you should be hearing right away. And you have received credit. If you do want a certificate, please email Marilee, and there's her email address, or you can find it on the website as well. And then at that point, we have the standard AIAOC information that we're required to send. I'll let you read that as well. You're probably done with it already. So I'll go ahead and turn this over to Michelle and Mike.
Okay. Hey, can we turn the screen over? I'm a control freak. How do we change this? Can I do that, Matt? Okay.
Arrow keys.
Oh, arrow keys. Got it.
Before you start, did you want to record today's session?
Might as well.
We are.
If you do, I think you have to do it from your end because it's your platform.
We're doing it.
We have the expertise in hand.
Okay. And then if you want, just send us the link and Danielle will clean it up.
Yeah.
And we'll go ahead and put it on the AIA Orange County YouTube channel.
If it doesn't go that well, we're going to lose it. But if it works out okay, we'll get it. Okay. All right. Okay. These proceedings have commenced here. The purpose of this presentation is to increase your level of sophistication and your toolkit for dealing with what Michelle and I call step 4. Any professional practice, it's a 5-step business plan. You get the work in, you get the work out, you get the invoices out, you get the money in, and then you drink it before it goes away. This is about 4, which is the most problematic of the steps in a lot of ways. Right? By way of brief introduction, our practice is devoted largely to working with AE firms in all sorts of aspects, kind of outsourced general counsel. So we set up firms and we do ownership transitions and M&A. In the meantime, we handle lawsuits and employment claims and contracts and whatever. So that's just kind of what we do for a living. I've been doing this for a little over 40 years, so for what that's worth. Michelle's only been here for about 20, but she's a fast learner and she's catching up. So I still have faith that she'll come around someday to get to my level, but we're working on it. Okay. The program. Problem with all these programs is there's too much information too fast. It's like the metaphor is drinking from a fire hose. So you get some information, and before it gets through short-term memory into there, more information comes in, and at the end of it, you heard everything, but you don't recall a whole lot. So we try to push back on that. It's a common problem, but I want to give me a moment to push back and make a pitch for handling that. One thing we do, this is multimedia, and I believe that everyone by now should have had the materials, the presentation materials, PowerPoint, etc., emailed to them. If that's not correct, maybe you can get a question and we'll have it sent to you during the course of the presentation. But the real trick is not what we do here so much, is active listening. You have to make an effort at this. And so we will try to go, we'll try to go relatively slowly, not too fast on these sort of things. If you have the materials, you might make a point of annotating them because it helps set the information. And then when this is over, tomorrow or whatever, next day, you're more than welcome to contact Michelle or me with questions you might have. So if you just make a note as we go, you might not pick it up today, but before this whole process is over, you'll have it. And there's questions, and we'll see how well the questions go. Sometimes with this format, it works well. Sometimes not as well. Matt LaPointe is kind of in charge of this, and he'll vet questions, and we'll see if that works. If it doesn't, we'll have some time at the end of the presentation for questions. And then again, you can call us tomorrow and we'll fill in details that you lost. So that's how we're trying to run it. And ideally, if you put all that together, people will actually not hear it, but actually absorb some useful information. Overview of this. This is about client management. That's an important part of getting paid, not selection. Now, in a perfect world, we'd all be able to select the clients we wanted, and you could vet them closely, and you wouldn't take on clients like overly leveraged developers or attorneys. You'd take on better clients than that. But that's not always the case. And not always free to reject clients, because sometimes you have payroll to make. So good advice, select your clients carefully. Practical advice, get who you can get and manage them well. The second part is about leverage. It's the art of having someone want to write you a check, not litigation. The first thing that comes to mind with lawyers and accounts receivable and collection matters is there's going to be a lawsuit. That's the last thing, literally, the last thing you want to do. A lawsuit is a loss. We'll do more on this later about how they work a little bit. But the bottom line here is, if you've started a lawsuit, you're already lost. It's a matter of damage control, how much money you can recover at the end of the legal fees, etc. So the trick is to have tools in your toolkit, ways, methods, to have people want to write you a check rather than have me process and go through a 2-year litigation cycle. So if that makes sense, let's start with the next thing here. Client management. Michelle, have you ever managed a client?
No, they always manage me.
All right.
No, I'm just kidding. As we said, we're not talking about the selection of client. This is once we're already into a project. Oftentimes, I am called at the beginning of a problem. It's typically tied to collection issues. And probably most of the time we spend trying to figure out how to get the client on our side, not only to solve whatever has happened, but also to make sure that when we put in our ad service or we send our invoice for our fees, they get paid. They view us as a team player. My view on, just like as I view myself as a lawyer, is that we're the team. We don't yell, we don't scream, we are very firm in what we need to do, but we are always there trying to answer the client's questions, trying to answer the contractor's questions, because I just think it helps with getting paid getting the project done to completion. So I have a very much of a team player attitude, even when it comes to collections. Understanding your contract is a big, is very important to me. What I find with the principals in the larger firms, and I don't know how many of you are with larger firms, but that the PMs are so busy running around, they don't necessarily understand what the contract calls for payment, for ad services, for understanding the underlying crime. And what I would say here as a caveat to everybody is spend more time doing that, spend more time teaching, spend more time understanding it, so that, and we'll talk about some of the war stories later, getting paid on that because you understand the contract can go a long way, especially even understanding the general contractor's contract. And then understanding, what we mean by understanding and meeting the client needs is keeping your client informed, sending the emails, understanding the schedule, communicating, so that, again, when you send your invoice for your ad services or your progress payments, they are well received, as opposed to, wait a minute, why did you spend 5 hours on this? It's almost a pre-sold. And then on the last side is your value. Obviously, you probably didn't get the job unless you were good at what you did. But my point there is to make sure you're being timely, make sure you're doing, you're meeting your standard of care, those sorts of things. Mike, did you have anything to say on that before we kind of moved on?
Let me give a couple of thoughts on this. One thing that sounds unlawyer-like, it's a people business. All your businesses, my business, every business is a people business. And relationships matter. So if a client trusts you, respects you, ideally likes you, a lot of things get worked out. We don't have a lot of collection problems. The opposite is true when those things aren't in place. My goal is for you to have a relationship with your client that's good enough that you can proactively deliver bad news. When everything's going great and you're making all the promises, life is easy. But that's not the way a lot of projects go. And so when it comes to the rough spots, can you have a candid conversation with your client without blowing things up? That's the relationship that will serve you well in getting paid. There's another thing, just at the risk of a war story here, but I gotta do it. This part about being valued, not fungible. You want to have something to offer, you have something that they can't replace easily, something that they value. And I learned this from, not telling tales out of school, but years ago from Art Danilian, who's a great architect, been around for a long time, love the guy. But this is many years ago when I was kind of starting out, and we were negotiating the contract with a developer. And we're at a table, and rows and rows, we don't do that anymore, now it's email, but at a table, nose to nose, we're talking about this guy. And I'm making the points because there's legal things that have to be understood and granted. And Art's talking about his design, and the great design. And I said, Art, what are you doing? You got the job, I'm negotiating the contract now. No, he knew what he was doing and I didn't. You sell all the time, and that makes things a whole lot easier. Now, what about good contracts?
Okay, so this is what I spend the better part of every day doing. But the right to collection is not only founded just in the law, but is mostly tied by your contracts, which you guys, as you know, are supposed to have under California law. And one of the provisions is payment, including the right to add services. I'm going to spend a little bit of time kind of going through all these provisions to help, negotiate. You might want to make sure they're in your contracts. You can talk to me later if you want to know, well, what do I do in this situation? But there are certain provisions in your contracts that should be reviewed. If not, if you have your PMs reviewing them for something, but I do think that the principals, those are truly responsible for meeting budget deadlines, really should understand in their contracts so that when an issue regarding payment comes up, you are already kind of familiar with how the firm wants to approach it. And assuming, as Mike was saying, if you have a really good relationship with your client, it's almost pre-sold. It makes it a lot easier to go to your client and say, geez, remember we talked about this, I really don't want to pull this trigger, but X. And then if it really does go down that route, we've got some, I will call them arrows, to fire off to help perhaps get things across the goal line, even if you guys decide to take a little less on your collections. So I believe that the negotiation of a contract is a little bit of a dating process. I am always checking out to see how the client is treating you, how the lawyer's treating me. I also believe that in the clearer the contract drafting, it's actually easier before issues can come up. I say, why don't we address it now while we're all still friends? So, and that typically will get us to the next step, which is, oh, okay, well, yeah, that makes a lot of sense. Let's address it here. Because oftentimes I'll hear from the other side, well, why do we have to address this now? Because it's easier, and my comment always back is, A, we're still friends, and two, we're not really dealing with the issue right now. So let's talk about it in the abstract. So what are things that we try to address? For collection provisions only, there's obviously all sorts of things we do. But the first provision I will start with is the copyrights. We'll get to exactly how you get them, how you give them away, but I think before you transfer or allow the transfer of some or a portion of your design to the owner, even ownership of the hard documents, I think you need to make sure that you don't give them up at the beginning. If you read some of the fine print, it's typically in the buried, it'll say, upon creation, this belongs to the owner. And I would just tell you that in your contract, you should be scratching that out, and you should be tying any ownership or any right to use to first being paid. And that includes payment even just for undisputed invoices. But I think that is often missed because the paragraph is typically like this long and nobody wants to read it. But payment, but understanding when it ties, how it ties can become big, especially if they don't pay. We'll get to that later, but that's a big issue for me, and it can have huge leverage if an issue comes up regarding payment. One oftentimes thing we put in a contract is, well, when can we deem that you're in breach? We'll get into how we do that later, but I'm starting to add, or I'm starting to see, and in some clever contracts that we have, it will say that a delinquent payment in any invoice is actually considered a material breach. So we don't even have to we've already agreed up front that if you don't pay our invoices, we can deem it in breach and try to seek collection for that. And I'm not arguing that, and that just takes away one of the lawyer's arguments. So paying attention to payment provisions in tab 1, it should be in tab 1 or tab 2, we'll have the invoicing provisions. If you want to take a look at kind of a standard off-the-shelf provisions regarding that. In addition, things we look at for this limited right to equitable set-off. This is I actually don't like to see it, but I think it's in the law anyway. The idea there, and Mike, you can speak to this more because you deal with this even more in litigation than I do, is we assert collection for $50,000 and they come back and say, well, geez, those change orders are worth $50,000, so we're going to set off your invoice by that. So it's in there. Sometimes it's an often time we use it in collection litigation. But Mike, did you want to say anything more about that before I move on to the other ones?
That's an issue which the common law is they have a right to set it off. You can change that by contract. You
Right.
can say you have no right to withhold fees which have not been held legally liable. That's sort of the small print we print in there. You stick tab 2.
I believe the B101 has it in there as well.
Yes.
That you cannot withhold payment until something has been adjudicated against you.
Yeah.
So that's something to be looking for and or putting into your standard contracts. In addition, interest, while not contractually required, would apply via the California Constitution, but I think putting something a little bit more like we put 1.5% per month on any late invoice I'm also starting to see late fees being adjusted and retainers. Although I'm not sure how successful retainers are for your practice, but I do try to do that. I see that in interior design, retainers a lot. Because what'll happen is that they put in all their front end, they've got furniture and fixtures and all sorts of stuff that they've ordered, and then someone decides to go somewhere else. So a retainer can be very, very useful. I'm seeing termination fees, those sorts of things. But these are things to make sure that you're not losing your fee in the event of, either collection issues, they terminate, those sorts of things. A word about attorney's fees. They're a double-edged sword. They can drive malpractice litigation. They can be great for collection, but they can be used against you in a malpractice suit. One of the tricks we've been using is trying to cap the attorney's fees so that they can't be the driving force in a malpractice action, but they can help us in a collection lawsuit where we can get our attorney's fees back. Typically, it's not as expensive to litigate a collection lawsuit as it is a malpractice action. And then finally, I've already talked about the exemplar invoicing provisions. It is important to understand in your contracts when you're supposed to do your invoicing, who you're supposed to get it to, when. And I'm going to add one thing to here. One of the things I've been starting to add for those of you who are doing prime contract DB, where your client isn't the owner, but your client is submitting invoices to the owner, is I'm starting to add prompt, timely submission to the owner of the invoices. I've run into at least 2 scenarios in the last 6 months where we've sent a very carefully worded letter to our client saying, can you let us know that you actually sent our $250,000 invoice to the owner? Mike, before, that's kind of all I have on the collection provisions. I could talk about everything else, but that's not why we're here.
Well, let me do just a couple of parts of this. Go back to the first thing there, the protective scope. If you don't know it now, you heard it here first. When you make a fee claim, there's almost a natural response to have a cross complaint for malpractice come back against you. So, or for if you make a mistake, there's a natural response to hold up your earned fees because of that mistake. What I found out years ago is I drafted the perfect contract, had everything I wanted in there. And it started with scope and fee and then all sorts of legal stuff that's very, very helpful. But it didn't matter because when I'd come back 2 years later in the lawsuit, I would find that my contract was stapled to the developer's contract for scope and fee only. And all my neat legal provisions were gone, trashed. Only the developers lasted. What I started doing, kind of 3 a.m. epiphany that's worked well for a long time, is in the scope, I'll have basic and additional services, and I'll have service clarifications, which basically rewrites the scope in a lot of ways. Writing the scope on a good day, it's hard to write both sides of it. We're going to do this, but not this. But then it gets cut off anyhow. So in any event, take a look at tab 1. Now it's a ridiculous document. It's way too complete. It needs work and editing and adjusting to any given firm. But the notion of having scope with a lot of what would be general conditions in the old days, which are now very useful, is worthwhile. So take a look at it, see if ideas pop out at you, things you could use that would go into your contract clarifying scope that would make you less vulnerable to withholding fees or whatever. So that's what I think. But I think in terms of that part, that's probably all right now. I'm going to flesh out a little bit more what Michelle said about attorney's fees, because there's a lot packed in there that's not obvious to non-lawyers. Lawyers are, I'm going to break a union rule here, sometimes egotistical and very competitive. So when you have a contract that calls for the prevailing party to get attorney's fees, so that's not the law basically, but if you put it in the contract, then it's too many times the lawsuit becomes about who's going to win fees. And the merits get pushed aside, and it's all an ego contest for the fees. What Michelle's talking about, our solution to this, if you don't have an attorney's fees clause, you've lost a real leverage to collect your fees. If you have an attorney's fees clause, you have a real risk if there's a malpractice claim of the fees going out of control. So what we've done is set up an attorney's fees clause, which is fair and balanced and works, but it's limited to $25,000. Because I can collect a lot of fee for $25,000, and I'm not worried about $1 million attorney's fees claim at the end of a lawsuit. So that's kind of a little expansion on why the question mark attorney risk is. It's got a question mark there. Two-edged sword, as she said, but you can work in a way that it's only got one bad edge.
Are there any questions? Oftentimes people have questions about contract, and again, we're not saying to walk away from a client contract based on these things. It's just to make note of them. They are things that you may want to ask for in your contract negotiation, or make sure that they're there, or decide, these are more important than others. But I would not consider these walkaways. So if I'm posturing, I would if I'm negotiating my contract, collection provisions are great. I'm actually going to see how the client's going to treat me if we're not paid, but I'm not going to walk away. I'm probably not going to walk away unless they're completely egregious in some of these provisions.
Okay. Let's talk about unrealistic client expectations. And the tab here is really kind of two parts of it here. The need for project contingencies. This gets back to what I'm saying. A lot of times it's hard to collect your money because the owner is asserting set-offs or counterclaims for your fault. The reality is that in the law, errors and omissions are expected, and you're not legally liable for every mistake you make. There's a whole notion of a standard of practice, which by law is not perfect, and so there will be errors and omissions in your plan. When we define construction documents, we actually put in there in a kind of more subtle way that the plans can be implemented with only routine errors, omissions, clarifications, etc. So that's the reality. That's what I mean here by SOP versus E&O. There's a standard of practice, which means you're going to have some problems and some extra costs at the end of the job. You're going to have it. You know it. The law acknowledges that. And errors and omissions, because it's your mistake. Why shouldn't you pay for your mistake? That's an attitude thing. You have to get worked out with an owner. Because if they're thinking you're going to pay for every dime that's related to anything less than perfect in your plans, we're going to have a problem. And we're right, by the way, but we're going to have a problem. And another kind of related aspect to that, the developers have their pro forma, and I've got this, I should have this project here by now at this cost, and I don't. And I did nothing wrong. So who's at fault? And you just have to understand, development, real estate development is a very risky business. Development has risk, and not every setback, not every disappointment is somebody's fault or deserving of compensation. That's a conversation you might have with your client, I might have with your client's lawyer, but you got to get that pecking order straight, or it's really difficult to collect fees if there's any question with your work, which there always will be.
Well, and again, Mike, I would even say before lawyers get involved or you even calling us, if you're seeing an issue come up on the project that may affect your fee, getting out in front of it, we talked about being a team player. This is where you get out, you start explaining what's going on, because they conflate so often the difference between a design professional and a contractor. So this is me on trying to get out in front of it, and so you're seen as a team player versus somebody who just needs to get paid.
Yeah.
It make it difficult when you actually want to get paid.
The second part of that, these are really jobs, I think, for professional candor. Again, you have to be able to deliver bad news to your client, to take adverse positions without blowing everything up. That's just part of client management. But that probably gets exacerbated by creating or allowing to fester unrealistic expectations. I don't know how many see. I come into the lawsuit in the post-mortem, and you can kind of see what happened. Is the project started with not a generous schedule and a kind of not a generous fee, but or construction cost, but it's doable. And then the client says, "I need a little bit faster. I need to move this around. We've had some delays here. I need to make them up." And the architect says, "Well, it's got to be tight. Oh, and we need to value engineer. I got to get some money out of this. I can't print all this. It's got to be tight." No, it's unrealistic. At some point, you have to say, "This is your expectations for how much you can get for how much money is not, and how much time. They're not realistic." And by tight, they hear, "Okay, tight, you get it done." By tight, you're saying, "I can't be responsible for this. This is not realistic." So you have to say it out loud. You have to use the right words. If you let it pass, people hear what they want to hear. They're here. You said it was tight, but you said you could do it, right? You didn't say you couldn't do it. So that's something I would look for there.
Mike, can I just jump in there?
Yeah.
So on the contracting side, if you're dealing, like I've actually had this where, who signed a contract 6 months after we started? But as Mike was saying, being proactive, we had, the background is we were working for someone else who was a contractor, so it was a design build agreement. And they had, I guess, fallen off the planet negotiating with the owner and actually had signed a contract with an old schedule. They come back to us and my client calls me and says, I don't even know what to do. And as Mike was saying, you cannot stay silent. That was the client management at that point wasn't even the owner. It was the design builder. And going back and saying, we can't do this, and not staying silent. You can't play ostrich in client management, because as Mike says, in the record, there will be nothing there. In addition, your client, which might be a design builder, it might be an owner, will be very upset if you didn't speak up. Now that ended up working out because we were very upfront about it and we refused to sign anything. It also had LDs, liquidated damages, attached to it. But that it's an example of, had they not properly discussed it with their client, it could have been an absolute disaster on the back end. So.
Let me just, one other thought here, just because it bothers me and I see it a lot, of changes. Sometimes client wants changes. Custom residential's critical for this, but not just them. I've seen school districts do it. And the architect often answer is, well, okay. And there's not a candid discussion of, I understand why you do it, that's a good idea, but it will cost X and take Y time. Your decision. But you have that conversation and you document it. Because otherwise, you'll get this huge bill. Would you come for your additional services and stuff? It's just an invitation to a train wreck. So candor up front is just, frankly, critical to avoid a lot of collection problems later.
Right, and I would add in like the value engineering part of that. Oftentimes your client thinks value engineering is part of their services. So when you get into an ad scenario, you would say, oh, so we're clear, we didn't include value engineering. Again, you're educating your client prior to for them getting an ad service. Going back, understanding your client, understanding your contract, and then it becomes just a lot easier than when you go and try to get paid.
Yeah. You should know that when we talk behind your back, we call value engineering litigation engineering.
Well, that's because you're the litigator and I do the front end.
Yeah. So now, this is me.
This is you.
There's two aspects of this. Obviously, you keep your AR current. The contract probably calls for that. You should be invoicing, running, following up for this, not letting it sit. You gotta push that. It's easy, relatively easy, to collect small bills. I've seen bills in hundreds of thousands of bucks that surprise people later. That's a lawsuit. So you keep it current. But that's especially true with additional services. And I don't know how many times the instructions come to change this, do that, hold here. And the PM's thinking it's extra, but we're not saying it real loud. And we're not saying it in writing. And then when you present the client with a surprise bill later, you shouldn't be surprised if you have trouble getting paid. So keep it current, and especially additional services on the table, candid up front. This is coming, and then you invoice them properly so they actually see that and can't pretend they didn't know later.
And again, and so I from a more, because Mike litigates all these back end stuff, I try to keep people out of it. On the front end, a lot of times, and this is more oftentimes I'm seeing them in your owner contracts and even your DB, the failure to properly invoice not only for your basic progress payments, but also for your ad services can result in waivers. I mean, written waivers, which in California are legal. So we can't say enough, which is if it says get it in by the 15th, do it by the 15th. Obviously, there can be modifications and those sorts of things. But generally speaking, if your contract says you don't do it promptly, you do waive it, that can be enforceable and be very difficult to collect on the back end, especially if, you know, for whatever reason you didn't invoice for like 2 months, and your client just got out in front of you. Mike's point on keeping the AR current is really important. Sometimes your projects move so fast that you don't know just how much in fee you are. We've actually had a couple clients where I about fell off my chair when I found out how much they billed in a 60-day period. So really keeping an eye on that. I deal with this all the time. Hey, can you keep me advised if your fees are going to go over X? But I just think that's really just good client communication. Hey, look, by the way, we're incurring X fees. You know, it's going to be coming. Are you going to get us paid? Those sorts of things. And a couple of war stories, little ones. The ad services one. Had a client, I don't know, I've never even seen this before, but they were asked to do their services, not a big deal. They actually got a planning approval letter, but the letter was kind of like, hey, Mr. Consultant, I think it was a geo consultant, go back and just give us a signed certification letter, make sure you're okay with the underlying plans. So that particular consultant took it upon themselves to expand their scope of services. My client says, well, wait a minute here, hold everything. There's nothing wrong with my plans. They all meet the standard of care. They meet the code of compliance. And at the very beginning of this process, they told the client it was an ad service and then never sent a follow-up invoice because the client said, I don't want to see an invoice until this is done. So a 6-month period happened between the date they first started getting all these ad service, and they did communicate it in writing, to actually sending the invoice to the client. And the client fell over because they had no idea it was coming. So what those good invoicing procedures would have done is A, communicate to the client that I told you there was going to be ad services, they're coming per the contract, and then maybe what I would have considered an overzealous consultant's expansion of scope would have ended in month 1, not month 6. So, and now my client's trying to get paid for probably properly added ad services on a very annoyed client. My second story is deals with a prime. I'm finding that sometimes the contractors just are not timely submitting to the owner. The prime consultant, prime contractors not properly submitting their invoices. And this actually turned out where my client didn't do it, and their sub filed a lien. So, and it was just a mistake, this, that, and the other thing, but what I'm saying is that understanding that, getting stuff timely to not only to your client, but also when you get it to your client, making sure they're getting it to theirs so that you can invoke some of these payment provisions. And I don't think there's anything wrong while you're still friends, or even while things are getting a little out of hand, advising people, here's what the payment says, here's why I did it, those sorts of things. Communication, again, that's your relationship with your client. And like I said, I because you get repeat business based on your relationships, I think it's just super important. And those are just two stories. Those were more recent ones.
Okay. Assuming that your client management is less than totally effective, we now turn to the concept of collection leverage, how you actually get people to want to write you a check. They don't like it, but they choose to do that, as opposed to a court order 2 years after a lawsuit's filed. So, begin with here, Michelle, why don't you tell us about stopping work?
All right, so our goal here, as Mike said, is we are not trying to start a lawsuit. Our goal here is what can we do in order to get, especially if the owner's ignoring us, trying to get the owner or whoever's going to pay our bill to pay attention to us, and whether or not we can do that and not safely. So there's two things on this slide. I'm going to start with a stop work. Mike and I are going to go back a little bit on this, but one of your first options is to stop work. Please, 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 before you decide to stop work, you call your lawyer. You discuss it. A stop work decision is not only based on what your contract says, but just the good old fashioned, what is going on the ground. I have had people state they're gonna stop work, they're not gonna do anything, and the tenant who they built out their TIs for is going to default under the lease. They're gonna default under their financial documents. And so my comment here is that before you start to stop work, you need to take a look at two things. One, just the good old fashioned circumstances. And then what does your contract say? Most of the time you cannot claim that the owner or whoever your client is in breach of contract unless it's a material breach. Now, we talked a little bit about contract provisions. Sometimes it says, hey, you fail to pay us, that's deemed a material breach. Okay, well, that's an easy analysis. Oftentimes your contracts don't say that, and that's okay. But the analysis of whether or not the level of non-payment has reached material breach is an issue. I have actually heard, I've never done this, but I've actually heard lawyers who've taken a position that their client had invoiced like $100,000 and they'd been paid $99,000, and something had happened on the last $1,000, and they were holding up the project. They decided to stop work on a $1,000 invoice, and I thought to myself, I'm not sure that even rises to the level of material breach. I think they could be in a more hot water when the owner screams back delays, late fees, if there's LDs, those sorts of things. So when you are analyzing this, it's facts, it's a discussion with what does my contract say, and where are we at in the project? Are there milestones that the client must hit? And so maybe stopping work is not the best decision. Mike, what could possibly go wrong?
Let me talk about a couple of things there. In terms of material breach, this is a classic aspect of the law. The rule is a material breach excuses performance from the other party. Material breach. Then the question comes up, well, what is that exactly? And the law isn't dumb, they know that. So we don't just say material breach, we say, well, it's substantial under the circumstances. What don't you understand about that? And your answer to that question comes at the end of a lawsuit. That's a factual question resolved, in the worst case scenario, in a jury trial 2 years later. So the problem is, as Michelle's saying, when you're making this decision, you might have a good case, you might have a great case, contractual case for stopping, but it's not a perfect case and it can be challenged. So you do this carefully.
Yes, and with thought.
Yeah. I think there's also another notion here. This is true for professions, yours and ours. Let's say you have a great case, a great contractual case for stopping work, but consequences would be dire. You leave the client in the lurch. This is where we've got this tab 3 here is a jury instruction. That's what a jury is told when they're deciding a factual question. So that's a situation where you can be liable for professional abandonment, even though you had a strong legal case, but you shouldn't have done a thing. So again, very powerful. If you do it successfully, you will get paid. But it's a nuclear weapon, so it has its risks as well. So.
Do you want to say a word about that word though? So some contracts include provisions such as, hey, you agree to continue to work through disputes. So oftentimes when we're reviewing our contracts, we're looking for that phrase. If you're negotiating, you might want to say something like, we'll work provided you pay us for undisputed services. So that our very clever material breach argument isn't done before we can even write the letter. So that's why when the contract comes up, it's a discussion of facts and law and circumstances.
Everything in law is arguable, everything. So you have to pay me at least the undisputed amount of the fee. Well, any lawyer with a dam can find a dispute. So it's just, it's a poker game as much as a service thing. But that's that. Let me talk about
Go ahead, Mike.
copyright. Well, I'll make it simple. The easy thing is you have copyright rights, and they can be very, very powerful. And you can use it as leverage to get paid, or even get paid afterwards. But here I want to take a little kind of related tutorial, because copyright seems to be one of life's mysteries. So it's kind of important in your profession to understand what a copyright is and how it can be used to your advantage. So give me a couple minutes and I'll go off trail here and we'll come back and see how it fits into this. As a matter of law, or federal law, when you create something that's artistic and put it in tangible form, and I'll include in that a computer program or whatever, just it's not just you're talking, but it's in some form. You have, at the instant of that creation, a copyright right, and that can gives you the power to limit other people's use of your copyright. So that's.
Okay, Mike, you want to go to the next slide? That has all your copyright stuff.
Well, I'm actually a little bit off this thing too. These are basic questions I thought might be useful here, but I wanted to expand a little bit more.
Oh, okay. I'm sorry. Yes.
No, it's a good point. But so this is the part where you have it. Now, what can you actually do with copyright? You can stop a party from using it. That's not simple. That's not, again, everything's arguable in our world. But to actually use it, there's a question of, is there some creative aspect in your work? And that's, the law is a very, very hair trigger. But the practice is, these are tried in federal courts by overworked and underpaid federal magistrates. And they like to clear their calendar. So there's a real question, if you really want to use the copyright, there's going to be a real question of, do you have copyrightable materials here? The law, in its guidance, recognizes this. Buildings are usually, basically, a collection of very routine, uncopyrightable features: doors, windows, halls, whatever. So why do you get a copyright in that? It's the way it's put together in some expressive, artistic way that can do it. And for my purposes, when I'm working on this sort of thing, what I want to see is the front of the building and the entrance. Because the apartment building, the home, it all probably looks alike. Here's a whole, but something in the appearance that's a little unique. Now we have a copyright. We can't just threaten, but might be able to enforce. But if you do this, copyright is not slam dunk. When we're using copyright as leverage, I get real dumb about this. And so copyright's copyright. Usually the other guy doesn't understand it anyhow. And so we just say copyright violation and all hell breaks loose. Truth of the matter is, maybe it does, maybe it doesn't. There's things to argue about, but you've got it. The next question is, how do you, when can you withhold it? That gets back to the material breach sort of thing. As a matter of law, the contract probably says this, but if it doesn't, your client retains you to do a design work and you create something that's copyrightable. If nothing else is said, the client has a license, an implied license to use that copyright. So you start with the idea that they can use it. When can you take that back? Material breach. What is a material breach? Well, we just been down that path, but you have that there. But there's another aspect, and this is what gets back to the contract sort of stuff. When you have copyright rights in a document, the owner contracts, if they're drafted by anyone who knows what they're doing, are almost certainly going to say the owner takes the copyright, that you sell the copyright. Now, the only way you can lose a copyright is by an instrument in writing signed by the owner. But that's your contract. So if the contract qualifies your copyright rights, then you can lose them. You sold them, and that's a valid way to transfer them. And then there's a question of, well, I sold it to you for the $100,000 fee, but you know what? You didn't pay me all the fee, so you breached it. Well, and then now we're off in the road again. I think my point, I do have one, is these are very factually complex questions. But for purposes of collecting fees, it's a very good leverage, a very good argument to have. So you should understand you have copyright. You should be careful about giving it away, or being able to get it back if they don't pay you. And then it is usually so threatening that it gets disproportionate effect. And if it doesn't bother you, watch the lender go crazy. So if there's a copyright claim on a project, that's great leverage, but don't kid yourself that that's a slam dunk if you don't work the leverage to get something resolved and move on to the lawsuit. Okay. That's thank you for this. That's my brief tutorial on copyright sort of stuff.
For those that are interested, I mean, if that's something you want to do, especially, custom design, but anything, if you think it's something that you want to think about, note that all the attorney's fees, the punitive damages, the treble damages, all that stuff requires registration and prior to infringement, or further infringement. We often do this for clients, especially in the design phase. They will have done entitlement drawings. They're trying to get the whole project entitled. There's an issue with payment, or maybe they're not going to get paid, or they're not going to get sold. That is a time to start thinking about copywriting your plans. What are the benefits of a federal copyright? Like I said, you get, in law, you don't need it, but if you want enhanced damages, enhanced rights, you must register it with the Federal Copyright Office. I think the fee is about $55, not too bad, and it's per building, per design. If you are looking to sue, it's a lot more expensive because you can speed up the process, but that's something my office does all the time, so we're happy to help you through that. Note that if this is something that you want to do and you want to pay your $55, it is actually effective the date you register it. So if it takes the Copyright Office 3 months to give you your certificate of registration, it goes back to the date that you actually made the application. And can be we've used it very successful in lawsuits, but again, it's a function of when, how, circumstances of use, those sorts of things. And again, my only caveat here is, remember, with the fourth bullet point is, how can I lose my copyright? In the contract, words like upon creation means that you may have lost it when you created it versus being tied to payment. So this is just something you need to pay attention to, not only on the front end, but then what happens if they're not paying you? And can we use it? Or have we lost it? Have we inadvertently given it away?
Actually, something I should have mentioned, the last part is there. If you've got a copyright, if it, you're going to certainly have an arguable copyright. If I get a whiff of a fee dispute coming up or slow payment, register the copyright. I got a paralegal to do it left-handed, $55, and and now my clout, my threat is much greater. And attorney knows vaunted attorney's fees, which are one way in this case. So, a registered copyright, if you have it, is good. So that's just a natural first step, I think of almost intuitively now, to enhance the copyright before you talk to the other guy about it. But,
Right, yeah.
Okay. Now, where were we here?
Second tier.
Yes, second tier. So the first things are really good to use in this. These are a little less important. I'll start with this. For public works projects in California, K through 12, community college districts, university, those sort of things, government buildings, there are prompt pay statutes. They're a little confusing, and they can be fact specific, and the agency or the type or whatever. So I don't have the digest of all the situations that could come up. But if you're working on a public works, think prompt pay. And then if you're not paid promptly, RERORA might have statutory leverage to get paid. Now, how do these work? Basically, there's time periods in the various codes and statutes. There's time periods of when you should be paid, when you must be paid. And that can be 45 days, 30 days. For a sub-consultant, it can be 15 days. So, but it's in that time frame. It's a matter of weeks. So it's not there. If after that, the penalty is 1.5% interest per month, 18% a year, I guess. You kind of put it on your credit card. So that is something that can provide some real leverage in the right kind of project, in a public works project. The owner or the prime has the ability to withhold up to 150% of what you're claiming, if they've made the counterclaim. If they have a claim against you for damages, they can withhold 150% of their claim. You get it eventually. It's not a final determination, but in terms of the prompt pay, they're excused from the prompt pay if they're disputing the quality of your services. If they're not, it's kind of a slam dunk. If they are, again, off to the races and back to the legal system. Right? But bottom line, K through 12 or whatever, think prompt pay. Might work very well for you. Michelle, what do you think about lender notifications?
So, lender notification, this is referring specifically to, I'm sure every one of you have either seen, reviewed, or signed, are the lender consents. Also, architect certificates of compliance, that's often what they are seen. I see them in the collection tier as being important, basically 2 points in time. The first one is when your client is first starting to get financing for a project, and you're sent the 5-page overbroad architect certificate that you just want to sign, but it probably has in there a provision that says that you certify or warrant or covenant or whatever that the owner has paid you to date. They're current. There's no default under the agreement. It also probably has a second provision that says, if the owner fails to pay you, you have notification obligations to them. So if you've never read one, you probably should read them because they can become important in this way. If you are owed a significant amount prior to the financing, you can show your client the lender consent and say, I'd love to sign this, but I really can't because you owe me $150,000. Now, I can tell you almost without, everybody gets paid when they go back to their owner before they close the loan, because once you make the lender aware of it, the lender says, you need to make sure this is paid prior to close. So reading them, understanding, and making sure that your invoices are current, because I can also tell you those lender consents also include that if they default if the owner defaults prior to the bank picking up, you're probably not going to get paid. You're probably going to waive all your rights to those prior fees. So very important to read that. The second time frame that the lender consent is important is after we financed and the owner doesn't pay for whatever reason. The borrower is absconded with the funds, they've got cost overruns, those sorts of things. And remember, I said there's generally a provision in all these lender consents that requires you, obligates you to go back to the lender and let them know that the borrower is in default. So that's a perfect opportunity again to go back to your client saying, I really don't want to do this, but you're kind of putting me in this position. I need to get paid. Otherwise, I'm going to have to, by contract, have to tell the lender that you're in breach, potential breach. You haven't paid me, whatever we're going to call it. And that can have, as a way to get paid, a very quick, easy resolution of trying to get that involved. Do you have anything before I go to the lien rights?
No, let's see. Yeah, just my comment or my notion of the lender notification obligations, it's a nice problem to have. Because you'd hate to tell on the lender, but you might have to.
Right. So again, it's for those of you who do those, note that they're in there. They're often overbroad. They expand your scope. Like I said, you may not even have known that you had that obligation, but just be aware of them. They can be very useful, especially if you're not getting paid. Lien rights. Everybody loves liens. Oh my gosh, why can't I lien this project? Blah, blah, blah. Isn't this a lot of fun? I want to get paid. I think the reason we put this in tier 2 is it can be effective. I have seen it be effective, but it really is not one of my most favorite arrows to play. I like to threaten it if I'm going to actually do it, but there are two types, for those of you who are unfamiliar, there are two types of liens in California. There's the design professional lien that attaches prior to construction commencing. So shovel in the ground, the grading commencing. There's a design professional fee. There are very specific statutory requirements that must be met prior to having a design professional lien. In essence, you must have a contract with the owner. You must not have been paid. You must have had some sort of governmental consent, planning. You've been through plan checks, something like that, indicating that the government has approved it. We had to send out the 10-day notice. But there's minimum statutory requirements on that. That design professional lien, if filed prior to construction, is very effective. It works very much like a mechanics lien, what I'll get to in a moment. The design professional lien, like a mechanics lien, must be foreclosed within 90 days of its filing. So those of you who thought you were getting away from litigation, think again. Once you file that lien, if they don't pay, you get to file a lawsuit to commence foreclosure, which then can bring up all those other things. But the design professional lien, it's great, especially if, you're first in line. Let me put it this way. Mechanics liens. Mechanics liens, again, this is post-construction mechanics liens. These have very specific statutory requirements, not the least of which is typically the 20-day preliminary notice, unless you're accepted by law. It requires somebody paying attention to whether or not you have to do the preliminary notice, because if you don't, you probably don't get all your fees back to the beginning of construction. Written contracts, and again, once you file the lien, even if you have rights to a lien, if you're the 15th lien holder on the project, think back to 2008, for those of you who are practicing. I think of SunCal Marblehead. All the super lenders took priority. So I didn't care if you were lien number 28, you were never going to get paid, because the thing about a lien, even if you get a judgment, is it gets wiped out when the owner goes belly up, files bankruptcy. Okay, or it gets foreclosed on. They just go away. There's not much I can do. So while they can be effective, especially in a really strong financial market, I have seen them almost be wasted or throwaway rights when there's more tight financial times. We're kind of at a weird economic time. So again, it's something to consider. It's just not my favorite. And typically, like I said, if you're way down under the mortgage lenders, you're going to sit there and again, the first mortgage lender, deed of trust lender, bank who's on that is going to get paid, and you're not. It's going to wipe it away. Doesn't mean you lose all your collection rights, like the ability to still sue for breach of contract, but your lien right will go away.
I was going to say a word in defense of liens. All that you say is true. There's another aspect to it. I can easily see a hardball developer or contractor say, go ahead, file your lien. And in 90 days, you're going to have a lawsuit or get out of here. And finally, I think it's flawed and it's a slander of title, and I'm going to sue you if you don't do it. But what I hear instead is a lender in the background saying, clear the lien. You're breaching the covenants in your loan. Get the lien off the property. So the direct client might be willing to fight, but the lenders are not. They want that taken care of.
Right. And it can help provided the borrower is still flush with cash. So I've also seen it forced right into bankruptcy. So again, as you can see right here, they can be really good, they can be really bad. It's just not as I wouldn't say they're bad. They may not be as effective as you think. That's why they're probably the bottom one on second tier.
Okay.
For me.
Yes. All right. Third tier. Talk about this. Interest, maybe it's obvious, but maybe it's not. One thing I learned in 1991 is when the market crashed and everyone's chasing developers to get what money they can out of them. There you could see this conceptually. Two stacks of creditor claims, ones that were charging interest and ones that weren't. My clients usually weren't, and you're just dead. So it's often we waive interest at the end to resolve something and collect it, but it's leverage and it's a problem. So it's an advantage, and you need to look at your contract. Your contract affects it, and then there's common law statutory interest rights too, but that could be lost or enhanced by the contract. But in any event, you need some interest right. Otherwise, why pay you this month? Why not next month? Why not 2 months from now? So that was that part of it. Attorney's fees clause, we mentioned before, the two-edged sword. If you have an attorney's fees clause, then when it comes to joining the battle, you have the potential of recovering your fees, and it's good. So if you really owed the money and you're going to win the lawsuit, that's nice to have, because I tell the other guy, not only am I going to be bothering you to collect the money that you owe for earned fees, but you should also know you're paying me to do this. Read your contract. So that's kind of fun. The other side of it, though, is they get out of control. They control the litigation, tail that wags the dog, and you can end up with unlimited amounts of attorney's fees for other attorneys, for the attorneys for other parties. So use them carefully. The best thing we've come up so far is have them, but have them limited in amount. So they cover fee claims and not other things, but there's that part of it.
And also there's a couple. So in California, a one-way attorney's fees clause is by statute made dual, so it applies either side.
Yeah.
Not the case for those of you practicing in other jurisdictions. So a word to the wise when you're doing contract negotiation. I saw some of the attendees. I know some of you do them out of state, but our prevailing party attorney's fees clause that's made mutual in California may not be applicable in other states. And trying to write around that in California is good luck. It's not going to happen. That's why we kind of went to the cap.
Yeah. Okay. Look at the last thing here, litigation threat, and another kind of related to toil. We're making light of litigation, which is, kind of questionable because, frankly, For us, it's profitable and often entertaining. But for clients, there are these problems. So again, just a rough Mr. Toad's Wild Ride overview of litigation in California today. You can't work it out. You can't get the stuff. You're not paid. You're going to get the money, so you file your lawsuit. First of all, that takes some time, which often, if I'm threatening litigation, I will actually draft a very intimidatingly good complaint and provide it as a courtesy copy to the guy I'm about to sue, or I'm threatening to sue. Raises that up. But then there's also filing fees. So you're $800 out of the chute there, and then you got to get it served, et cetera, et cetera. And so it's not free. And then other fees could come onto that. And so and now you're kind of locked in to a process. So that's not too good. It will move with glacial speed. The answer's due in 30 days. They typically get a continuance for another 30 days. And so, time's going by and the clock's ticking and nothing's happening very fast. And the end of the road is not even in sight. When they actually do answer, very likely they get a cross complaint. One of the most common causes of malpractice claims in California are responses to fee claims. You sued them for earned fees. Their defense is, though you didn't do a good job, you didn't earn the fees, or you cost me damage I can set off against the fees. And matters they wouldn't raise on their own, now, offense is the best defense. So you kind of have to factor in there will probably be a cross complaint involved there, which then there's another 30, 90 days, et cetera, et cetera. And then it goes into a court process that's endless. And there will be discovery responses and document productions and depositions, expensive, time-consuming, whatever. That's just part of the program there. At some stage, the trial court, because they will not try these cases, they will, by one way or another, demand, suggest that you go to mediation. Well, there's a day or two and $10,000 a day, but that's kind of the way those things work. And then there'll be endless continuances and schedules and stuff. The idea in California is to get most cases done in about a year. The reality is 2 years. And as a practical matter, if there's much to it, other things get involved, it can go up to 5 years for its crowding on. So when we make light of litigation, using litigation, that's what we have in mind. So threat of litigation opens a lot of doors to get things done, that's fine. But before you take the step, think about that. And in particular, maybe get back to the capstone for this presentation. Don't go to a lawyer and have him file a lawsuit on your behalf. There's a lot of things you need to do, can do better than start a lawsuit. Okay. What is this?
So my one thing on the litigation,
Yeah. I see there's a question here.
There is a question, yeah, but before we moved on to the question,
okay.
it goes back to the liens. I personally won't do it, but if you're gonna threaten litigation, be serious about it. Otherwise, you lose a lot of leverage, a lot of gravitas. So if you actually are gonna go down that road, make sure you're willing to file the lawsuit. Make sure you're willing to do the front the legal fees and deal with the potential malpractice action coming down your way. A empty threat can be disastrous.
Okay.
That's what I found.
Yeah. Well, I make a lot of them, but it's how you make them. It's a poker game.
Right.
Question: can an owner sell property when you have a lien against it? The answer is probably not. People don't like to buy liens. You can work around them. You can bond around them or something. But that liens have a real bad effect on the ability to close a sale.
Yeah. So the lien. So if the real question, the lien typically can't just travel with the land. So what would happen would be they would enter into escrow, and as part of the process for the sale of the land, you would get a demand letter. We've done this before, and the demand letter from the escrow company will say, what are you owed? to date, and if we close, per diem interest, those sorts of things. So, they can pay it prior to close, but Mike is right, that lien won't, go away by itself, and no buyer is gonna wanna take that on, and I can tell you right now, no title insurer is gonna take it on either. Provided it's a valid lien, so. And just note, if you don't file, again, a word of caution, the lien is great, but you have to file the lawsuit within 90 days, or the lien goes away by operation of law.
Okay.
So.
All right. I think we might have done it. Let me again renew. If you have other questions that come up there, or you want to do it now, feel free to contact either Michelle or me. We can answer or fill in stuff or correct misunderstandings or whatever. But otherwise, I think realistically, these proceedings are concluded. Thank you very much.
Is Jeff
Thank you,
com-
Mike and Michelle.
How do we conclude them? Yes. Okay. Are we done?
And there we go.
Okay.